those that are benefiting from the special mandate dealing with independence of judges and lawyers are specifically judges, prosecutors, and lawyers. We have a tendency to treat before what are considered the institutional partners in this mandate. That means the judiciary, properly speaking, and those judicial officers, and also prosecutors and public defenders. But in fact, democracy and rule of law requires all of them to comply with certain standards, but also that the people on the other side of the counter, those that are claiming for justice, representing people in breach of the law and people who has been the victim of a wrongdoing, can have justice. And so those are lawyers, and those lawyers have to come to us. We are very much close, or pretty much close, to international human rights NGOs and NGOs in different parts of the world. But in fact, at this time in life, NGOs normally act on pushing public interest. Sometimes when you meet, like this weekend, with actors themselves, you have their personal stories, their personal records, their opinions, their views. Those are the people that go to the courthouse every day, who face the problem, who are under pressure, who may be injured, who may be in jail, like some of them in the room today. So the point of meeting with them, for me, has been really an extraordinary weekend, because the consultation was great, because we had people of first level of the great majority of the Eastern European countries, because they are what we call a first source information. So what we could exchange with them relating to how the rules are, which are the gaps on the rules, which is the gap between what the rule says and the enforcement level in the country. And also those practices that are institutionalized, between inverted commas, even though they are written nowhere. Those are really important issues in order to draft a report as accurate as possible. So I'm really happy of having had the possibility of meeting all of them during this weekend. And in fact, everything has been okay. I'm really happy. The point is that, I do have to prepare reports dealing with thematic issues. My main proposal for the first years of the mandate will be put forward in the report I'm presenting to the Human Rights Council on Wednesday, where I will be proposing the adoption of indicators of judicial, of the independence and of the impartiality of the justice system. Meaning, in the justice system, all the actors I've been referring to in my previous explanation. What I'm thinking of is just of drafting a report on the situation of lawyers, specifically flagging the situation of lawyers at risk, and that will be presented to the General Assembly. The idea is having meetings like this one. Sometimes it's not possible, so gathering information in order to, on the one side, try to put together all the international standards that are there, that are valid for states. Some of them are binding obligations because these are treaty obligations or customary international rules. Others are just suggestions that can be taken by states in order to enforce at the local level, and at the same time to flag how in certain countries some institutions can be denaturalized and used in order to as a punishment against lawyers. For instance, one of the main and recurrent features we heard during this weekend is disbarment. Okay, every bar association has a chapter on disbarment. Every bar association has a chapter on disciplinary proceedings. However, sometimes these disciplinary proceedings are not used with the purpose for which those disciplinary procedures are there, that is to say, to punish the bad lawyer, the one who departs from his or her duties towards the client, towards the society. Sometimes these procedures are used in order to punish someone who's bothering because he's taking care of the defense of someone who's suspicious from a political point of view, very sensitive case, even targeted communities in a society. Those vulnerable groups, I don't like very much the expression vulnerable, but those groups that are in a very risky position, and if ever a lawyer takes care of their rights, well, he may be targeted, he may be the object of those disciplinary proceedings. So the point is just to flag these issues. And I think that the report will be useful not only for lawyers themselves in the practice of their profession, for bar associations all over the world who work very well or who want to improve the way in which they are working, but also will be useful for the civil society, NGOs, and the United Nations. Democracies in the world should take care of that. It's not only possible to say, okay, how nice your report, we are doing nothing. Okay, if you mean that, just try to support. Open your mouth, voice it. Well, you know, education in human rights is something that plays in different levels. I think that education in human rights is a sort of long-term investment. You start educating law graduates in human rights and other graduates, but law graduates substantially, and in 10 years, in 15 years, you'll have a community of law practitioners who will be aware of human rights and who will just have human rights permeating their activity. But in the short term, you also need human rights. You need training of human rights, not only for lawyers who are practicing law, but also for judges, for prosecutors, for public defenders, for judicial officials. The point is that once you recover democracy or rule of law after a very hard period of time, that has happened to many states in the world and states in this region too, okay, you try to implement, to enforce democratic institutions, but democracy is not genetic. Democracy is a culture. You have to study. You have to make up your mind and to have democratic reactions, not only in an institutional way, in a professional way, but also in your everyday life. So the point is that in the long term, you invest in education, and in the long run, you'll have people educated in human rights, practicing not only law, but other professions too. But in the short term, what you need is training. You need to train. Of course, I'm very much fond of that, on the one side because I am a law professor and I'm teaching human rights, but at the same time, I had the experience at home. I'm Argentinian, and after the dictatorship, when we recovered the possibility of universities, public universities, having their own governing bodies, the board at the University of Buenos Aires Law School, where I work and where I studied, decided to change the curriculum and to include human rights as a mandatory subject. Well, some 20 years later, we had a generation of men and women, not my generation, but the younger one, generation of men and women between 40 and 50, who became those that are the heads of the NGOs, those that are getting judge positions in the judiciary, and they know how to react on that. That doesn't mean that Argentina is outside the world and everything is perfect. No, very far from there. But in fact, we have improved a lot the approach, the human rights approach of the judiciary and of the legal profession all over these years. Mainly, not all the universities in the country, but ours is the biggest, is the one that produces the great majority of law graduates in the country. So we make a difference with that. And I truly support that. I think that's important. Well, you know, the mandate has 3 goals established by resolution. On the one side, to assess what is well done and what are the weaknesses of the justice systems all over the world. Secondly, to handle communications that are communications on situations in which human rights of all those involved in the mandate, those actors of the judicial system are in breach. So we send communications to states asking for explanation. We flag the situation for states to take measures. And the third one is just pushing the borders of existing present international human rights law, that is to say, to propose new approaches to existing rules, and sometimes to propose new interpretations or to adopt new instruments. The idea is that the mandate cannot become itself the policeman or the policewoman of independence of judges and lawyers all over the world. But doing all the constraints we have, this is not a full-time job, there are not so many resources. So what I try to do is just to capitalize what we have and to exert some sort of incidence in some countries in which, on the one side, what we can do is just to call upon the international community because something very, very bad is taking place there, because there are lots of wrongs. And on the other side, just to help some countries that, in fact, want to improve their judiciary with the adoption of new legislation or new practices on that. So for doing that, almost everything has already been said. I don't want to reinvent the wheel. So what I decided is just that what we are lacking is information, first source information on judicial systems in the world. And I'm proposing the Council to adopt, to allow me to set up a set of indicators, not very sophisticated, so as to be satisfied by the great majority of countries, in order to know certain features of the justice systems in the world. And there are some questions that are not very difficult to be answered that can provide the picture on how the judiciary and the legal profession is working in the country. If ever you put the question, okay, what are the reasons, which are the fields or the causes for starting disciplinary proceedings against lawyers in your country or against judges? With that, you have a picture of how things are going in that field. You can also put the question, okay, who and on what grounds are judges appointed in your country? So with that information, I think we can all work. Civil society, judges, lawyers, and other judicial officials. The UN will have a certain mapping exercise that may be interesting, and the mandate will have more serious basis in order to try to elaborate on these issues. So I'm crossing fingers for states to endorse the indicators next Wednesday.